Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello, my name is Nicholas Robertson and I do nothing but make coronavirus podcast update alerts to respond to the ever-changing guidance notes on the furlough scheme. Well, that's not quite true. This is in fact podcast number 172, and even if it feels like I've done 171 other podcasts on the coronavirus alert update schedule thing, the truth is this is actually fourth time around. We've had further guidance from the UK government on the operation of the furlough scheme. The guidance note that was published on 15th April has now been updated 2 whole days later to provide more information and details on what to claim for and how to go about it. At the same time, the guidance note addressed to employees, the one that's called Check If Your Employer Can Use the Coronavirus Job Retention Scheme, has also been updated, and bizarrely, that guidance note contains information which employers need to know as well as employees, and some of that information doesn't appear in the employer's guidance note. Go figure. We'll look at some of the more straightforward changes across the 2 guidance notes before we look at the significant challenges which exist because of the tension between the guidance notes and the Treasury direction, which was also published on 15th April. Let's start by looking at the employer's guidance note, the latest version. This guidance note, full title, Check If You Can Claim for Your Employees' Wages Through the Coronavirus Job Retention Scheme, is, as I say now, on its 4th iteration. The guidance note has had further material added to it as new issues come into view. For example, there's an emphasis on the fact that HMRC will check claims made through the scheme and payments can be withheld or required to be repaid if it turns out the information is dishonest, fraudulent or inaccurate. So mere inaccuracy could result in a repayment. The employee guidance note, in fact, builds on this theme and encourages employees to disclose the identity of any employers making fraudulent claims. The employer's guidance note has made clear for some time that an employee made redundant who had stopped working for an employer after the 28th of February 2020 can be re-employed by the employer and put straight onto furlough. The guidance note now makes it clear they can't be put on furlough until they've rejoined employer, and then only from that date. In other words, they can't have employment retrospectively deemed to go back to the 28th of February 2020 if they joined on the 1st of April. Guidance note's advice on fixed-term contracts has also been expanded, but in a way that is probably a bit unhelpful if I'm honest about it. It confirms, as we already knew, that employees on fixed-term contracts can be furloughed. We knew that. We also knew that the furlough period could be extended beyond the end of the original date on which the contract was due to expire. The contract can be renewed, it can be extended, and the furlough period continued. A section has now been added into the guidance note to make it clear that the contract in question must be renewed or extended before it's expired. Fixed-term contracts which have ended without extension or renewal on or before 19th March 2020 will, according to this section, simply not qualify to be furloughed once they've ended. However, this overlooks the point that employers are entitled to rehire employees where their employment ended at any point after 28th February 2020 for any reason. Therefore, the apparent trap which sees the fixed-term contract have to be renewed or extended before it expires is largely meaningless. That said, of course, it's going to be much better if employers take prompt action to extend or renew the fixed-term contracts if they're intending to furlough the individual. Employers should also ensure that there is written evidence that the contract has been continued, even if it's only a note of a call in which the extension was agreed. Guidance note now states that individuals who have been on furlough when they return to work must be taken off furlough. They can be furloughed again, but each separate instance of furlough must be for a minimum of 3 consecutive weeks. We think this is not as drastic as it first appears. It's not requiring employees to be kept on furlough leave for multiples of 3 weeks only, and anything short disqualifies the final period of furlough leave. It's simply saying that if an employee is on furlough and then is rotated back to work again, if they are subsequently sent on furlough, that subsequent furlough period is treated as a new furlough period rather than an extension of the old one. This means that staff are being rotated on and off furlough. A business cycle like that will probably have to have a minimum 3 weeks on, 3 weeks off cycle. The information to be provided in order to make a claim has not changed. However, we now have an explicit requirement that employees should retain all records and calculations in respect to the employer's claims for furlough monies. This is to include records of the amount claimed for each furloughed employee and the period in respect to which the individual is furloughed and a claim has been made under the scheme. In other words, and not surprisingly, the employers are going to have to show their workings if they're claiming money under the scheme, or have to be able to show their workings of HMRC audits. Turning now to the employee guidance note, this was also reissued on the 17th of April and has been updated. And the guidance note is directly relevant to employers as well as employees. The key point is that at long last we now have some guidance on the issue of holidays and holiday pay for furloughed employees. The guidance note that says whilst employees are furloughed, they will continue to accrue leave in line with the employment contract. This is, of course, subject to the statutory minimum rights to holiday. This is no surprise. The virtually unanimous understanding of commentators was that employers would need to recognise that there were costs for furloughing staff which would not be recoverable. One of those costs that employees would be continuing to accrue holiday whilst they were on furlough. The guidance note goes on to say that employees can take holiday whilst on furlough. This is extremely important. Whilst most people had assumed, particularly after the ACAS guidance note had referenced taking holiday whilst on furlough, that the furlough scheme did not prevent an individual taking holiday, it is helpful to have this expressly confirmed. The nightmare scenario, of course, was that one day of holiday might invalidate a 3-week furlough period, leaving the employer badly out of pocket. Guidance note goes on to say that the working time regulations require holiday pay to be paid at your normal rate of pay, or, where your rate of pay varies, calculated on the basis of the average pay you received in the previous 52 working weeks. This seems to be clearly aimed at the situation where an employer has reduced the pay for staff who are on furlough and staff are taking holiday. In such circumstances, according to the guidance note, the employer should be paying at the normal rate of pay, which is presumably the rate that individuals would have received if they were not on furlough. Since there's nothing in the Treasury direction to contradict this, the guidance note's unchallenged on this point. It doesn't completely remove the issue, however. If employees' pay has been cut, irrespective of whether they're on furlough, does that affect the rate at which holiday pay would be paid? Similarly, if the rate of pay has been reduced, and let's assume it's been done with the appropriate agreement from the individuals, or it's otherwise been duly authorised under the contract, and the reduction is open-ended, what's the normal rate of pay? Clearly this is a question which is going to have to be resolved by the courts, unless the Treasury Department issues a revised direction and is made a condition of applying for the grant that employees have been paid at the full salary irrespective of any reduction after 28th February 2020. This is going to have to be resolved in the Employment Tribunal in due course. And this flows from the slightly odd status of the guidance. The guidance is guidance to employers applying for public monies under the furlough scheme. It's not suggested that the treatment of holiday leave amounts to a precondition for claiming payment. Imagine a situation where an employer, in ignorance of the guidance, pays the employees at the wrong rate for holiday taken. Since there's nothing in the Treasury direction, it would seem unlikely that this would mean that the employer is unable to make a claim in respect to those furloughed employees for that period. Instead, it's simply that the employees would have a claim in the tribunal that could point to the guidance note and its interpretation in support of their claim. Guidance note goes on to say that if individuals usually work bank holidays, then the employer can agree that the bank holiday day itself is covered by the application for the grant, and if the individual normally takes bank holiday as leave, then the employer either has to pay the top-up for that period up to the full rate, where there's been a pay reduction, or has to allow time off in lieu for that to be carried forward. Guidance note finishes this section by saying that the policy on holiday pay during furlough is quote-unquote under review. So I wouldn't rule out any further guidance on that in due course. Sadly, the guidance does not say anything explicit about whether employees can be required to take holiday during furlough. The guidance note is completely neutral on who has initiated the holiday being taken. It states, quote, "You can take holiday whilst on furlough," unquote. It's very, very broad, very sort of neutral as to who is choosing to take the holiday. Maybe this is what those who've created the guidance note have in mind. They have this particular issue in mind when flagging that there may be further policy on holiday pay during furlough. Perhaps if there were to be widespread evidence that employers were disproportionately running down holiday entitlements and in effect double counting by reducing their holiday costs and benefiting from public monies, that might prompt further policy to be announced. Let's turn now to the bits where there's a just clear contradiction between the guidance notes and the Treasury direction. There are two areas where there is a significant conflict between the guidance notes, and in particular the employer's guidance note, and the Treasury direction. Given that the guidance notes were issued 2 days after the publication of the direction, and one certainly hopes that those doing the guidance notes had seen a draft of the Treasury direction before it was put out, it's truly remarkable that these inconsistencies exist. Nevertheless, employers need to know what to do in the current circumstances. The first, and by far the biggest, is what is said about employee consent to being furloughed. We talked about this in the last guidance update, but just a quick reminder, Treasury direction said that an employee had to have been instructed to cease all work in relation to their employment in order for that employee to qualify as a furloughed employee. And in passing, a thought occurred to me after we had done our last guidance. Presumably that means an employee who disobeys that instruction, does some unauthorised work, would still seem to be furloughed unless the employer consented to that work being done. Anyway, paragraph 6.7 of the direction said, and still says, an employee has been instructed by the employer to cease all work in relation to their employment only if the employer and employee have agreed in writing, which may be in an electronic form such as an email, that the employee will cease all work in relation to their employment. Sadly, whilst this was, of course, quite exceedingly unhelpful, it did at least have the merit of being reasonably clear. Employee consent in writing was required. It could be given by email. It ignited a predictable howl of protests from employers who, in reliance on the previous iterations of the guidance note, had not understood that they needed to get consent in writing from the employees, and who had gone ahead and furloughed employees. Well, the latest iteration of the guidance note now says, heading, agreeing to furlough employees. Employers should discuss with their staff and make any changes to the employment contract by agreement. To be eligible for the grant, employers must confirm in writing to their employee confirming that they have been furloughed. If this is done in a way that is consistent with employment law, that consent is valid for the purpose of claiming the CJRS. There needs to be a written record, but the employee does not have to provide a written response. The last two sentences, if this is done in a way that is consistent with employment law, that consent is valid, and there needs to be a written record, but the employee does not have to provide a written response. That has been added to the guidance 2 days after the direction. Nothing has been taken out of the guidance from 15th of April. Well, how is this to be read consistently with the direction? Well, the first problem is the guidance note itself is pretty unclear. It says that in order to be eligible for the grant, employers have to confirm in writing to employees that they have been furloughed. So far, so clear. It then says if this is done, then provided this is consistent with employment law, that consent is valid for the purpose of claiming the furlough grant. A natural reading of that would assume that this is the employer writing to confirm the furlough arrangement, but there's no reference to consent needed to write to someone to confirm a furlough agreement. We think it's probably intending to mean the consent referred to is the consent to changes in the employment contract, but that only applies where employers are making changes to the employment contract by agreement. In other words, if an employer is making a change to the employment contract, then it needs to be duly authorised, but does not require written consent. We think that it probably follows from this that the writers of the guidance note are proceeding on the assumption that furloughing staff is always a change to the employment contract. On that basis, this part of the guidance note means that if you're furloughing staff and the process of furloughing staff is authorised by employment law, then you don't need to get the consent of the employee. In other words, ordinary employment law principles apply. Presumably the reference to employment law simply means law applying to employees in whatever format. So We have a situation where the guidance note seems to be saying, however opaquely, that you don't need to get written consent when you're furloughing an employee if the instruction is not a breach of contract and is a reasonable instruction. So back to what we understood the position to be originally before the 15th of April guidance and the Treasury direction. So we're good to go. Well, no, of course not, because there's a problem. None of this seems to engage with paragraph 6.7 of the Treasury direction, which will have precedence. The direction is the legislative framework. The guidance note is simply guidance. The Treasury direction continues to say that employees have to be agreed in writing, and I think it's pretty much impossible to read the two together consistently unless the words in the direction agreed in writing are somehow understood to mean any authorisation mandated by employment law is good enough. Well, even that's pretty challenging. What about a situation where the employee gets sent on furlough without consenting, has a claim for breach of contract, but does nothing? Well, after a period of time, they will be taken to have waived that. Is that going to be good enough for consent? Seems a long way from what the direction is talking about. So what do employers do? Well, our suggestion is going to be employers are going to have to take a pragmatic view and they're going to have to do something. If employers are still in the process of furloughing staff, then consider whether it's feasible to get consent in some form or another. The difficulty is that presumably then staff can refuse to consent, and the employer will be trying to work out whether it's created an additional problem by giving the staff the option to refuse to consent to furlough. We know of cases where staff have protested against being furloughed because they thought it was a precursor to being made redundant. We think that if objections are from individual employees, not widespread groups, and most people are willing to sign any consent letter, then maybe the employer will simply then elect to furlough compulsorily the refuseniks without their consent. This should avoid the issue becoming divisive between those who've agreed to be furloughed and those who haven't. The employer will have reduced its risk significantly by obtaining majority consent, and for the individual refuseniks, HMRC may still accept the employer had the power to furlough unilaterally. Naturally, if pay cuts or other adverse changes are being implemented as well, then that will require individual personal consent. Where staff have already been furloughed, the question is a bit more tricky. The employer will need to consider whether it is best to go through a consent process to try and obtain retrospective consent, which isn't certain to work, or whether it's better to let sleeping dogs lie and trust that the makers of the guidance note and the authors of the Treasury direction might both be playing for the same side and attempting to reach a common outcome, and so the guidance notes approach can be relied on by employers. There's a separate problem, and that's in relation to where employees who are ill and whether they can be put on furlough leave. And it's very unclear. And whilst it's obviously less of a groundbreaking issue for employers compared to the previous issue, it's still extremely important that employers know whether they can furlough sick employees in the midst of a pandemic. The Treasury direction states, paragraph 6.3, where statutory sick pay is payable or liable to be payable in respect of an employee, whether or not a claim to statutory sick pay is made, at the time when the instruction, pausing the instruction to the employee to be furloughed, at a point when the instruction is given, that's called the original SSP, the period described in paragraph 6.1 brackets B brackets, the furlough period, in respect of the employee, does not begin until the original SSP has ended. Let me just go through that again, putting in the explanations as I go. So where statutory sick pay is payable or liable to be payable in respect of an employee at the point at which they are furloughed, then the furlough period does not begin until the original SSP has ended. Any subsequent entitlement to SSP by virtue of the employee becoming unfit for work again after the original SSP period has ended must be disregarded. Our view, therefore, based on paragraph 6.3, is it's not possible to furlough an employee who is entitled to receive statutory sick pay even if no SSP claim is made. Remember, statutory sick pay has now been extended to cover those who are self-isolating even if they're not sick, and there's probably a very significant financial difference between being on furlough and merely receiving statutory sick pay for many employees. However, guess what? The guidance note also addresses the issue of employees who are sick or self-isolating before they're furloughed. It states, quote, Short-term illness / self-isolation should not be a consideration in deciding whether to furlough an employee. If, however, employers want to furlough employees for business reasons and they are currently off sick, they are eligible to do so as with other employees. Employers are also entitled to furlough employees who are being shielded or off on long-term sick leave." Unquote. That's just completely contradictory to the direction. The guidance note expressly recognises that employees who are ill can be furloughed. The direction says they can't during their initial period of sick leave. Clearly, here, for most employers, the approach will be to make the claim for sick employees on the basis they can be furloughed. If claims for such employees are denied, it's unlikely to raise existential issues for the employer. Clearly, equally, employers who are relying on furloughing almost their entire workforce, but who do not obtain consent first, may be significantly more troubled about the consent point than the sickness point. It's to be hoped that the Treasury will realise the significant and unnecessary confusion that this has all caused, and may issue an amended Treasury direction in the near future, and as a matter of urgency. But today we saw the portal go live. No amended direction came out over the weekend. It's been nearly 3 days now since the last guidance. We're probably overdue some guidance, but as it is at the moment, employers are having to guess whether the direction or the guidance forms the better guide to what they should be doing. Naturally, if we hear more or there are further updates, then we will produce a further podcast on that. Thanks everyone for listening. Hope everyone stays safe, and until the next podcast, whether it's coronavirus update or not, take care.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.